wherever is practically possible to make it happen before Tuesday. We have even extended our period for going on recess to Tuesday. But unfortunately, the reconciliation, we don't want a situation where the Senate will pass a different version and then the House will pass a different version. So all our efforts is geared towards making sure that every committee of the House and that of the Senate will agree, since these are figures, that this is what is desirable at this time of our economic development as necessary requirement for bringing the economy out of recession. So once this has been agreed upon, then we now know that the Senate and the House have agreed, and then we can pass it in one day, detail by detail.
So that agreement is going to come after the recess?
Yeah, there is nothing we can do because the two committees of the appropriation did whatever was humanly possible to have some to have all the committee chairmen submit report. But the report we received from committee chairman is to the effect that certain MDGs in government refused to appear at the time when they were supposed to appear before the committee. And a lot of them, including ministers, didn't come to defend the budget. So it was practically impossible for us to meet the deadline. Otherwise, we have brought a very nice timetable, and I was in the committee of me and the Deputy Senate President that fashioned out what date we wanted to pass the budget. And we wanted to pass the budget even before now. But unfortunately, we had problem that was outside our control. MDGs, ministers, neglected to honor the invitation of the Senate for whatever it is.
Well, so we wish you a happy deliberations.
Thank you very much.
Well, thank
you very much.
Well, yeah. It looks like the waiting game on concerning the budget is definitely going to continue for a little while. We are now going straight into the chambers where two motions are slated to be moved, and then with a total of 10 bills that will be going for second reading. We wish you happy viewing. We'll see you at the end of the deliberations. Happy viewing.
And as of today, we have handed over Bakassi to Cameroon. And it takes just roughly 45 minutes from one of my local government areas to get to Bakassi. But within those 45 minutes, a lot of lives have been lost on a daily basis. We have a group of young people who call themselves Bakassi freedom fighters operating on the waters. In fact, they even have agents, and they have their own flag. So if you want to fish or you want to travel to Cameroon to go and do your normal trading, you have to go and pay money to the agents, and then they'll give you a white flag. You hoist it on your boat or on your ship, and that is the only way you will pass through that area. So they are now making money. They have turned themselves into revenue collectors, and those who refuse to pay or who refuse on a daily basis to adhere to what their directives are paid dearly with their lives. It is such a terrible situation that I never even thought that it would be possible for us to curtail the situation. But thank God for this bill. I know that once we pass it to relevant committees with a public hearing and bring in technical experts, we'll be able to marry our intention with international conventions and international law. And that way we can come up with a very robust legislation that will also take care of nationals of other countries who are operating on our waterways on a daily basis, from Nigeria across Togo up to Ghana. We have a maritime boundary with Ghana, and most of them are also operating and fishing on our waterways, and they are suffering daily from the acts of sea pirates. So, Mr. President, without mixing words, I support this bill, and I want to urge my colleagues to do so we can have an expeditious end to this, and then have a robust legislation that will not only cater for Nigerians, that will not only cater for nationals who are doing business through the seas in Nigeria, but also protect lives and properties and allow free trade, free flow of trade. And of course, it will also increase the economy. At a period of recession like this, we need to make sure that our borders are open enough for trade to flow so that we can bring this recession to an end. So I so support.
Very well, thank you, Senator James Manager.
Thank you, Mr. President. My highly respected colleagues, James Manager, CON Delta South. Mr. President, this is an important bill brought by Senator Effiong, my colleague and my dear brother from the Niger Delta, who of course understands what Sea-piracy is all about, because those of us who are from the Niger Delta, in fact, the art of the not just the Niger Delta, the art of the Niger Delta, we know what Sea-piracy is all about, and it is a very dangerous criminal activity that embarked upon by some criminal elements. Mr. President, the lead debate is very exclusive, and of course, the details are there. Mine is, Mr. President, I support this bill, undoubtedly, but the only thing that must be done here, because of the international implications, before it comes back for third reading, the committee must invite, in my humble view, invite some experts, particularly naval officers and professors of international law, like Professor Yobode. Let them come and look at the implications of what we are trying to do, so that whatever we do will not contravene some international laws that are governing law of the sea, and particularly sections 401 and 402 of the Criminal Code. Definitely that is insufficient, because we are talking about a specific law to guide an economic activity that is very important for the survival of this country. Mr. President, my respected colleagues, I support this bill because those of us from that area, we feel the pains, because from Sea-piracy, they also do quite a lot of other criminal activities. Ordinary people who are on their own, not just Sea-piracy, from pirating on the sea, of the ships, they will go into other activities that will create problems for the Niger Delta people. Mr. President, what is important is for us to have stringent laws that will provide sufficient basis for prosecution. Because right now, like somebody pointed out, it is difficult to arraign somebody because there is a gap between what Section 401 and 402 is providing, and then the other ones that are being guided by international laws. And then the other thing that was pointed out by somebody, which is very important, Mr. President, is to domesticate.
Thank you, Mr. President. I'm Senator Emmanuel Boacha, I represent Taraba South. Mr. President, I'm coming under Order 56.9, behavior of senators in the chambers. When the senator is speaking, no senator may converse aloud or make any noise or disturbance to interrupt him. Mr. President, the chamber is literally turned to a market square. There's a lot of noise going on. You may wish to intervene.
All right, thank you. The order is sustained. Distinguished colleagues, there were on live television. So let's try to conduct ourselves in a very orderly manner, please. If you want to converse, can converse in a low tone, or you can go to the tea room and have your conversation. Senator James Manager.
Thank you, Mr. President, and thank you, Emmanuel Boacha. I don't know, you are very far from the sea, but I'm sure this particular bill is important to all Nigerians, because what we get from there takes care of the entire country. Mr. President, my respected colleagues, this bill is important, it's apt, and there is no better time, like the Senate Minority Leader put it, there is no better time than now for us to expeditiously pass this bill, because so many things are happening. While the Sea-piracy is going down, the statistics of it going down elsewhere, some other places, Somalia and some other places in the world, the one of Nigeria is on the rise, and which is very unfortunate. And part of it is attributable to the fact that we do not have the appropriate laws to arraign and prosecute offenders. And that is one of the problems we have. I'm sure this particular bill, when passed into law, will adequately cure that which I see to be a lacuna. Mr. President, my respected colleagues, I urge everybody to support this bill and let us do something about it expeditiously. Thank you, Mr.
Thank you, Senator Jibril Barra.
Thank you, Mr. President. I am Barrow Jibrin. I represent Kano North. Mr. President, I want to first of all commend my friend, Senator Nelson, for sponsoring this very, very important bill. Mr. President, sea piracy is a threat to our national security. It is a threat to our economy. It is also a trend that is causing serious damage to our image as a country in the Committee of Nations. Goods that have been brought into this country are made to be more expensive because ships are always not comfortable where there is too much of piracy in the high seas. It therefore means that there will be more money paid for insurance and so on and so forth, which at the end of the day will be factored into the cost of such goods when it is brought into the country. So you can see it's doing a lot of damage to us because the cost of sea piracy goes directly to the consumers in our country, which is not really good and is not palatable. Mr. President, we also know that it's not good for the image of our country where this trend is being discouraged in other parts of the world. It's no longer what is going on, it has been stopped. But here, it's a trend that is now getting increased day in, day out. It is therefore important that a bill which is brought forward to deal with this matter is given the necessary and appropriate attention so that we can stop this menace. We all see, or we saw what was happening in Somalia some years ago. The kind of damage. Up to now is going on. It's going on there. So we need to put all hands on deck to deal with this matter, to deal with this menace appropriately, as quick as possible, as soon as possible, so that we can bring an end to this economic problem that has been brought to bear to our nation. I urge my colleagues to support this bill because of its importance. Thank you, Mr. President.
Very well, Senator Yaya Abdullahi.
Thank you, Mr. President. Though my constituency is very far, on the border of Nigeria with both the Benin Republic and the Niger Republic, the farthest constituency, but our fate is actually tied to the security of the maritime borders of this country. This bill, Mr. Senate President and my colleagues, is very important and vital to the maritime security, both fiscal and physical, in this country. We are quite aware of what had gone on the Gulf of Guinea Security Organization. I knew one time in either 2009 or 2010, we had calls to go to the American Council for Foreign Affairs in Washington to discuss this very vital issue of security in the Gulf of Guinea. Mr. President, maritime security, particularly in the Gulf of Guinea, is so vital not only to Nigeria but to the entire West African sub-region. And this sub-region, the security of this sub-region, is directly tied up with the economic and industrial development of this country, because without securing that region, the hope of Nigeria becoming the hub of business is completely out of the question. But like Senator Seosain said, Mr. President, this issue is a highly technical matter. Therefore, if we are going to take up this bill, we have to give it the kind of backing up with the kind of information and the kind of strategic information that's required, so that once the bill becomes law, it has taken care of the entire gamut of the issues that are at stake. There are some international conventions, law of the sea conference, that need to be adopted and enshrined into our laws by our legislature. There are also some binational and multilateral security conventions that also need to be domesticated. Therefore, I will urge that going forward in working out with this bill, we should engage all the necessary constituents, all the necessary international stakeholders, because I don't think we can just isolate this bill and treat it within our own committee. We have to reach out to the Ministry of Foreign Affairs. We have to reach out to the American African Command of the American Armed Forces. We have to reach out to all the relevant stakeholders so that by the time these bills come back to Asia, it really encapsulates and captures the entire gamut of interests, that should be captured, under this kind of thing. No opportunity should be really wasted, to make sure that the Gulf of Guinea is secure, because the security of the Gulf of Guinea is directly tied to the future industrial and social development of this country. I thank you, Mr. President.
All right, Senator Foster Angola. After Foster, we'll take Abdullah Adamu, Matthew, and then Senator Nala will round up and put the question.
My dear President of the Senate and distinguished colleagues, I am Senator Foster Angola. I represent the people of Bayelsa West Senatorial District. Mr. President and distinguished colleagues, I want to thank our distinguished brother Nelson Effiong for this bill. I'm speaking in support of this bill, but I have some serious amendments. Before then, I want to give you the reason. Sea piracy refers to all the things that are off the littoral borders of Nigeria. But we also have river piracy in Nigeria. The people of Nembe in Bayelsa, Ekremo, Brutu in Delta State, Andoni, Boni, Opobo, Kalabare in River State will tell you that what they face within the inland waters of Nigeria, in the creeks of the delta of the River Niger, are worse than what international people are facing. They cannot go home through the rivers, and we don't have roads. And to avoid our making another bill for river piracy, I would suggest that we amend this bill to read suppression of river piracy to suppression of river and sea and river piracy, or suppression of maritime crime, so that we don't do this work two times. Because I agree that the crime...
No, sorry. I think the bill is suppression of piracy. You didn't make any distinction here. Where is the C? No, what I have in this other paper is suppression of piracy. Okay, go ahead.
Indigenous and
Mike.
This mic don't bewitch what we are talking of. And therefore, I want to round up, crave the indulgence of our distinguished colleagues to note this important aspect of the crime of river piracy within the Nigerian borders, and then sea piracy at sea. Yes. With this, distinguished colleagues, I urge you to support this bill because it's what affects all of us. Thank you very much.
Sublime, Damu.
Thank you very much, Mr. President. I am Senator Abdullah Adamu, and I represent the people of Nasarawa West Senatorial District. Mr. President, I want to add my voice to those of my colleagues who have already spoken in support of this proposed bill. Mr. President, sea piracy is what, at the time, in the life of this country, we used to hear. We hear about, without the slightest imagination, that so soon we will begin to experience this in our shores. Sometimes back, we were talking about terrorism in some part of the world. For some 5-6 years now, we have been engulfed with acts of terrorism in our borders. The thing about Nigeria, Mr. President, is that whatever you see happen here, if you don't take appropriate steps to contain it, before you know what is happening, it becomes a major national issue and challenge. We are just now beginning to have a feel that Boko Haram will be a thing of the past. While this is happening, and we are beginning to say, well done to this administration, we suddenly began to have, kidnapping become a big national issue. And as if all this is not enough, we are now being faced with the issue of sea piracy. We have a very, very long coast, Mr. President. And unless and until we appreciate this and take appropriate measures to contain this situation, it may soon get out of hand. May God forbid that. Because of the fear that I have, and because of the implication that sea piracy will bring to our economy, Mr. President, to our security, and even our international reputation, for us to be lumped along with states that are known to be having this sea piracy problem, with Boko Haram on his way out, by the grace of God, with kidnapping and then sea piracy, we cannot afford to sit and watch these things. In the light of this, I want to commend the effort of our very, very distinguished colleague, Nelson F. Young, for initiating this bill. You do not have to be an inhabitant of any of the coastal communities to feel the impact of sea piracy in your life. It's there will be hope for every Nigerian, and particularly so our colleagues here, to stand up and support this bill so that we can be sure that we have a mechanism that is in place to check the occurrences and to make provision for measures that will serve as deterrent to those. And that the only thing that can do that is to have appropriate sanction along with this bill. So when we come to talk about the things that have to be done by way of sanctions and by way of punishment for offenders, we have to be very, very strict. Because if you have a very loose penalty provision for offenders, you are making it possible for them to continue. And not only that, to see how we can sensitize our people, particularly those in the coastal regions of this country, to be very, very up and doing with supplying appropriate information that can be very useful to our security agencies that may be saddled with the responsibility of ensuring good checking on our sea shores. With this comment, I wish to add my voice and support for the bill.
All right, Macho Rugid. After him, then the deputy Senate leader will now round it up.
Mr. President, distinguished colleagues, I'm Senator Matthew Urogide. I represent all the good people of Edo South Central District in Edo State. What of the bad? Mr. President, distinguished colleagues, I think this bill in its own right, by virtue of the lead debate that Senator Effiong has put forth, it has proved beyond reasonable doubt that this bill has to pass through second reading. Mr. President, the lead debate has told us very sufficiently what Anti-piracy is, the consequences, both on human lives, Nigerians and foreign nationals, and of course the very negative effect on our economy, particularly at this time, when of course the International Maritime Bureau too has come with facts that Nigeria is losing about $1.5 billion a day. Also, this bill has been able to tell us that even international discourse in the United Nations, in 2016 alone, about 8 foreign nationals are still missing from attacks by sea pirates. Mr. President, distinguished distinguished colleagues, I believe there is no need to belabor this bill. Senator Effiong has done enough research to inform us. I think what this bill now tends to pursue is the consequences by way of law that will stand in the way of sea piracy and the people who perpetrate the crime. That is life imprisonment and death penalty for those in cause of perpetrating the act kill other people. I think I want to urge each and every one to support this bill. What Senator Nelson has done is sufficient to give the background information. And we knowing that in Nigeria, particularly in recent times where we have been talking about militancy in the Niger Delta, we must cure the difference between sea piracy within the space of our international waters, and then of course the ones that are perpetrated by our own Niger Delta indigenes or Nigerians who are involved in, of course, militancy for the actualization of their own demands over resource control and such like. This one has to do with international crime, which of course is not pardonable. Therefore, we need this strict law, which this bill will provide, to be able to contain this crime. I so submit. Thank you very much.
Thank you. Finally, the Deputy Leader of the Senate, Mr. Nala.
Thank you very much, Mr. President and my distinguished colleagues. I think it's important for us to understand the reason why this bill can conveniently be called timeless. Now, the reason being that the International Maritime Organization, of which Nigeria is a member, have sat and agreed that there are certain compliance measures that every maritime country should comply with. And then it led to what they call ISPS code, of which piracy has a place specifically designed for it. Now, I'm aware that in the past, there has been attempt in order to meet the requirement of the International Maritime Organization requirement for complying with ISPS code. a presidential committee on maritime security was established and domiciled in the presidency. I'm equally aware that we have made a lot of appropriation to that committee by way of special grant, and certain equipments have equally been acquired. If I can remember, they had an aircraft called King Air for the purpose of maritime surveillance, and then monies were provided for the purpose of securing boats in all the maritime area at that time. Now, what am I trying to say? Is that at the committee level, it will be nice if all these things are coordinated and put under one roof and given a legal teeth, so that we do not continue to have a presidential committee existing independent of what the law seeks to establish. Secondly, Mr. President, in all over the world, we do not only rely on the provisions of our law. What we try to do is to provide adequate facilities for the prevention of piracy. We have not been funding the maritime police in this country for a very long time. Navy has always claimed the exclusivity to tie this down, which under statutory provision is not their own function. So I think that at the committee level, a detailed work should be done so that every agency of government will know what is required of it, and then we can now have one body that we can rely upon for the purpose of preventing maritime. But it is more important to the fact that for us to meet the requirement of International Maritime Organization as it relates to implementation of the ISPS code, and subsequently the function to which I said earlier was given to PICOMS, it will be nice to have a legal framework from which we can now catapult ourselves into compliance requirement of the International Maritime Organization. I therefore commend the effort of my bosom friend, distinguished Senator Nelson, in respect of this matter, and all my colleagues, that we allow the bill to get to the second reading, and then even at the committee level, to assist the committee to do a robust public hearing so that we can put this thing behind us as a country. Thank you very much, sir.
All right, thank you very distinguished colleagues. We spent more than 40 minutes debating this bill. To underscore the importance of this bill, the sea pirates have caused us very considerable embarrassment as a nation, and it has also done a lot of damage to our economy. The issue of the cost of insurance on goods coming from abroad has also been affected by the activities of these pirates. So I think they deserve the time given to this bill, and I'd like to thank you for very brilliant contributions. In the past, the Parliament have responded to this kind of call in making separate legislations for certain crimes that caused us national embarrassment, including terrorism, the obtaining money by false pretenses, corruption, and other such offenses, which are already in our criminal code and penal code. We've removed some of those crimes and then placed them under special legislations in order to deal with it aggressively. So this too has come as part of the issues. I believe we need to give special consideration and have a separate legislation to deal with it in view of the embarrassment it's causing to all of us. So I'd like to thank you for responding to this. But I'd like to add too that in addition to the law we're making today, we must also take advantage of the development in science and technology to effectively monitor our maritime environment and also ensure effective and real-time response when the pirates strike, to ensure that not only that these laws will be enforced, but also ensure that those who commit such crimes are apprehended and punished effectively. In that way, the essence of this law would have been achieved. So I'd like to thank everybody for their contributions. So on this note, I'd like to put the question. Those in support that this bill be read the second time, say aye. Those against, say nay. The ayes have it. Clerk of Senate.
Mr. President, distinguished senators, the bill for an act to make provisions for suppression of piracy and to provide for punishment for the offense of piracy and for matters connected therewith, 2017, second reading.
A bill for an act to make provisions for suppression of piracy and to provide for punishments for the offense of piracy and for other matters connected therewith, 2017, second reading, taken and referred to the Committee on Navy to report back within 4 weeks. Said Leader.
Mr. President, very distinguished colleagues, the fourth order of the day is the second reading of the Nigerian Postal Services Act, Cap N127 LFN 2004, Repeal and Reenactment Bill 2017. Distinguished senators will recall that the bill was read the first time in this chamber on Thursday, 9th March 2017. Mr. President, may we invite very distinguished Senator Benga Ashafa to move the motion for the bill to be read a second time.
Senator Ashafa.
Thank you, Mr. President. Senator Benga Ashafa, representing Lagos Senatorial District. Thank you for giving me this opportunity to present this bill, which, with all intent and purposes, is an economic bill. Mr. President, my highly respected colleagues, permit me to lead the debate on this all-important bill before us today. This bill was read the first time, as said by the Senate Leader, on Thursday, 9th March 2017. The bill seeks to repeal the Nigerian Postal Service Act, Cap N127 LFN 2004, and enact the Nigerian Postal Commission, the introduction of private sector participation in the provision of postal services, and the regulation of the postal sector, and for other related matters. Mr. President, distinguished colleagues, as you are all aware, the Nigerian Postal Service Act was an act of Parliament of 1992. You may all agree that the current trends in globalization, digital advancement in all facets of life has been on the fast lane. Thus, the need to keep up with the changing technological trend for the benefit of the nation. The bill seeks to establish the Nigerian Postal Commission with the sole and exclusive responsibility for the regulation and supervision of the postal sector. The Commission will facilitate investments in and entry into the Nigerian market, protect and promote the interests of consumers against unfair practices, including but not limited to matters related to tariffs, charges, availability of and quality of postal services. It will promote fair competition in the postal industry, protection of postal services, and facilities providers from misuse of market power or anti-competitive and unfair practices by other service or facilities providers or equipment suppliers. It will grant and renew licenses, undertake general responsibility for economic and technical regulation of the postal industry, among others. Mr. President, distinguished colleagues, the bill also seeks to establish a public postal operator with the sole responsibility of providing universal postal services in Nigeria. The public postal operator shall be a limited liability company in accordance with the provisions of the Companies and Allied Matters Act 2004. The Postmaster General shall be the chief executive of the public postal operator. Equally, the bill seeks to establish a Universal Postal Service Fund, UPSF, which harnesses monies from contributions by licensees, which shall be 2.5% of their annual turnover, gives
loans, aids, etc., as is being practiced world over. The fund shall be managed, administered by a board in accordance with the provisions of the Act. The UPS Fund Board shall appoint an independent and competent investment management firm as Universal Postal Service Fund Manager to, amongst other things, maintain the UPS Fund's financial accounts and records, estimating the amount needed annually to sustain the rate of network expansion determined by the Commission as appropriate to meet policy objectives, disbursing monies upon approval by the UPS Fund Board, etc. The bill also seeks to vest the administration and planning of the National Postcode System in the Commission. Also, the bill provides for offences, penalties, and trial of offences with the necessary sanctions. The bill for an act to repeal the Nigerian Postal Act and enact the Nigerian Postal Services Commission consists of 30 parts. Objectives and application: establishment of the Nigerian Postal Commission, functions and power of the Commission, staff of the Commission, financial provisions, responsibilities of the Minister and formulation of policy, licenses, license conditions, renewal and revocation, directions, inquiries and investigations by the Commission, investigations for purposes of administration, information gathering by Commission, register, regulations, guidelines by Commission, notification and resolution of disputes, agreements and undertakings, review of decisions, monitoring and reporting, general competition practices, tariff rate regulation, universal service obligation, public postal operator, service delivery condition, national postcode system and technical standards, offences, penalties and trial of offences, special powers of commission, legal proceedings, national interest matters, and miscellaneous. Financial requirements. Mr. President, distinguished colleagues, the Nigerian Postal Bill has no direct consequential financial implication on government, as it will take over the assets and liabilities of the existing Nigerian Postal Service. Mr. President, distinguished colleagues, I therefore call on my respected colleagues to give the bill the support it deserves in evolving a vibrant postal industry for the economic development of the nation. I so submit. Thank you. Right, this is a very straightforward bill. So we're just going to take a few comments. We hear from Malam Wakil, and then we'll take Basi Albert, and then Dino Marai. We should be rounding up.
Your Excellency, sir, distinguished colleagues, what are you saying? Your Excellency, you know Dino was his distraction. Distinguished colleagues, my name is Senator Malam Ali Wakili MNI. I represent Bauchi South. I am here, sir, to support the bill that will repeal Cap 127, laws of the Federation 2004. If we recall, last year I had a motion here on the same Nigerian Postal Services, where I called for rejuvenation and the reposition of the postal services. I spoke about the vast asset base of the postal service. I spoke of the potentials in terms of provision of service provision, in terms of employment, in terms of information technology development, in terms of provision of virtual offices and other services that are required. In line with the 21st century, sir, I think it will repeal the existing act and substitute it with a new one that will make it and will bring it to the world standard. It will be very good for us. As you said, the bill is a straightforward bill. I'm lending my credence to Senator Ashaba. I'm supporting the content of the bill. It's a repealment and it's an enactment. I will do everything possible to help it. Thank you, sir.
Very well. Thank you, Senator Basabat.
Thank you, Mr. President, my distinguished and respected colleagues. Mr. President, I rise to support this bill and to thank Senator Ashafa for doing a fantastic work on this bill. Mr. President, everybody agrees with us that the Nigerian Postal Service has totally collapsed, and a complete repeal of this act and a reenactment of the Nigerian Postal Commission will bring about a robust postal service in the country. It will also add value in the sense that the regulation of the competition in this industry will equally enhance the effectiveness of the Nigerian Postal Service. So it's a very straightforward bill, and I rise to support this bill in totality, and I believe very strongly that this bill will change the face of postal service in Nigeria. I thank you, Mr. President.
Thank you for that brief contribution. Senator Dino Malay.
Mr. President, my very respected colleagues, Dino Melaye, Kogi West. Mr. President, I want to appreciate the intellectual sagacity of Senator Ashafa in proposing this bill. It is true that the Postal Service Act cap number 127 has not only gone moribund, but as presently operational, cannot meet the technological and scientific demands of recent times. Postal service has gone beyond the analog approach of just posting letters. We've seen other Western countries graduate into other social services that have very great benefits to the nation. And I know that the Nigerian Postal Service is also undergoing these reforms. Just a few weeks ago, I'm aware that they signed an agreement with a company that is partnering with MasterCard and Visa Phone for money transfer across over 40 nations of the world now. But this bill will make all these operations very, very easy, especially when we are signing bilateral agreements with other countries. It will be difficult to move at the pace of other postal services across the globe if there is no enabling law that will satisfy and guarantee the operations of most of these international agencies with Nigerian Postal Service. So the bill is a welcome development. It will help to promote social service of the Nigerian Postal Service and also ease our exposure to MoneyGrams and other international agencies that the tariff always, or rather, their profit after tax is capital flight from Nigeria. So I want to commend you, and I ask my colleagues to please support this bill. Thank you.
All right, just to be gender sensitive, let me invite Senator Stella Odua to round up the debate on this, and then put the question. Dino, have your permission.
Thank you, Mr. President, my dear colleagues. Mr. President, my name is Stella Adezodwa. I represent Anambra North. I stand to support this wonderful bill in enhancing the potentials of Nigerian Postal Service Agency. Mr. President, there is no gainsaying that this particular agency has been in a state of comatose for a very long time. And the thing that puzzles me really is the platform that they currently have. There is no community in Nigeria where you don't have an office, a post office of some sort. And so they have huge platform that can enhance job creation. And indeed, Postal Agency, as its global best practice, is a revenue-generating agency. And so I believe when this is done and we have holistic overhaul and act is enacted to ensure that their practice is in line with global best practice, I think Nigeria would benefit immensely from this particular act. And so, Mr. President, I want to support this bill, and I want to urge my colleagues to support this bill because we need to have platforms that will be job creating and will be revenue generating at the same time. Thank you, Mr. President.
All right, thank you, distinguished colleagues. I want to thank you for your contributions again, and to note that at this stage of social media, the relevance of telecommunication postal services is diminishing, so it's absolutely necessary I will refresh it to meet with the demands of the time, and I think that's exactly what this bill seeks to do. So on this note, I'd like to put the question. Those in support that the Senate do not take a second reading of this bill, say aye. Those against say nay. The ayes have it. Back of Senate.
Mr. President, distinguished senators, a bill for an act to repeal the Nigerian Postal Services Act, cap number 127 LFN 2004, to provide for the operations and development of postal services, the establishment of the Nigerian Postal Commission, and for related matters, 2017, second reading.
Dear colleagues, a bill for an act to repeal the Nigerian Postal Services Act, cap number 127, Laws of the Federation, 2004, to provide for the operations and development of postal services, the establishment of the Nigerian Postal Commission, and for related matters, 2017, second reading taken, and referred to the Committee on Communications to report back within 4 weeks. Let me also say that the one relating to the piracy, the Committee on Judiciary as well as Maritime Transport should also get involved so that it will be holistically discussed, so that they'll be able to bring in their expertise, in enriching the content of that bill. Thank you. Senate Leader.
Commission is there.
Mr. President, very distinguished colleagues, the fifth order of the day is the second reading of the Arbitration and Reconciliation Act Amendment Bill 2017. Distinguished senators will recall that the bill was read the first time in this chamber on Thursday, 10th November 2016. Mr. President, you may wish to invite very distinguished Senator Mansurat Sumonu to move the motion for the bill to be read a second time.
Distinguished Senator Sumonu.
Why is number 3?
The President of the Senate, my name is Senator Mansura Sumonu, representing Oyo Central Senatorial District. Excuse me, this is my one. This is for the second one. So my one is different.
Go ahead. Put on a microphone, please.
The amendment of the Arbitration and Conciliation.
Do you have copies? Okay, go ahead.
Okay, that's us. Okay. Federation of LFN 2004 is necessary in order to bring the Act in line with modern standards. Arbitration has fast become the modern mode of dispute resolution, and it is necessary to update our statute in order not to be left behind by the advancing international trends. Mr. President, one of such trends is to empower arbitral panels to have authority to protect the subject matter of the dispute before them.
That is not your own.
Yeah, no.
Your own is attached here.
Yeah, but what do you have to put in the process? I know, that's what I said.
No, we go through this one now. No.
Mr. President, one of such trends is to empower arbitral panels to have authority to protect the subject matter on the dispute before them. Currently, under our laws, interim measures of protection issued by the arbitration panel in the form of an interim award under Section 13 of the Arbitration and Conciliation Act must be enforced by the court in the same manner as the final award. In effect, if a panel makes an interim or preliminary order in a case, such an order needs to be ratified by courts before enforcement. Interim orders are generally intended to assist the arbitral process toward the achievement of the final award, for example, the judgment. Interim orders preserve the subject matter of arbitration, as is the case in judicial proceedings in the courts. This Senate is aware of the backlog of cases in our courts and the fact that our judiciary is overburdened with litigation. For instance, to get a date in court to enforce an interim order can take months, by which time the reason for making the order may long have disappeared. Mr. President, the question we must ask ourselves is why we subject interim orders, and I stress the word interim, to ratification by courts, when the final award will surely go through the scrutiny and enforcement process of the courts. Arbitration is supposed to be faster and cheaper than litigation, but having to go back and forth to the courts forestalls the intent behind the entire process. The distinctive thing about arbitration is that parties have voluntarily signed up to it. There is no coercion to take part in the process. By electing to resolve disputes through arbitration when entering into an agreement, the parties are voluntarily empowered the arbitral panel to make decisions on the dispute. We should give the arbitral panel the legal backing to execute their mandate. It should be noted, Mr. President, that the proposed amendment also addresses grants for refusal of an arbitral award on the reason of composition. If the composition of the arbitral tribunal is therefore not in accordance with the law or agreement of the parties, a party against whom the award was made may apply for same to be set aside. This is the way things are done in more advanced nations, and we must follow suit so as not to be left behind. The amendment to the Act also seeks, among others, to ensure that an aggrieved party has recourse to challenge the award, irrespective of the country in which it was made. It recognizes that an award given with respect to an agreement that has been rendered invalid as a result of illegality or other violating factors may be rejected by the party against whom it was made. The unique thing about arbitration is that directly or indirectly, parties decide whom the umpire is. Therefore, there is a consensus that there is expertise in that field. If the expert believes an interim order will help along the way towards resolving the case, then it should be binding without being subjected to the court bureaucracy, especially because the final decision will be enforced by the courts anyway. We must also take note that arbitration is paid for by the parties, and this saves the government a lot of money. As for each arbitration, it is one less case that the taxpayer needs to fund. We as lawmakers must support this cost saving by not dragging cases back to court at every opportunity, particularly when parties have opted out. I must stress that there is an important difference between interim orders and final awards. Interim orders are made to aid the progress of arbitration by preserving the subject matter until the final awards are made. Final awards, however, are the judgments of the panel. This amendment seeks to make interim awards enforceable by the panels without having to go to court for the reasons stated above: time, money, and modernity, etc. It goes without saying that final awards need to be enforced by courts, and as Nigeria is a signatory to the New York Convention, we need not amend the provisions with relation to enforcement to final awards. The 8th Senate is a vibrant one that must leave the legacy of bringing Nigeria into the 21st century, and this amendment is one of the ways which we can achieve the vision. It is disheartening that local and international countries conducting business in Nigeria have arbitration clauses in their contracts, but choose the seat of arbitration to be foreign lands outside of Nigeria. If you ask them why they opt for this, they will tell you that it is because our laws slow down arbitration, because at every stage we have to run back to the courts. That if they wanted to spend a significant amount of time in court, they would not have opted for arbitration. Enforcement of foreign arbitral award is very important in international arbitration practice. If arbitral award made pursuant to arbitral proceedings cannot be enforced, then the arbitral process is hopeless and of no relevance. Our system cannot continue to be one that treats the issue as if arbitration award is governed by different legal regime and is therefore absolutely autonomous or is floating on an independent legal regime unconnected with legal regime governing course of action in civil matters, when in fact it aids the process of civil litigation in Nigeria. We must try to make Nigeria a hub for international dispute resolution, and the foundation towards achieving this is by having the right laws in place. It is important that this bill is passed in order to prevent the court's intervention in the commencement or continuation of arbitration, thereby defeating the purpose for which arbitration stands. President of the Senate, this is one of such laws, and I urge my distinguished colleagues to please support this amendment and bring Nigeria into the new age. And if you thank you.
All right, very distinguished colleague, but if you look at the next bill, I think it's also related to the one we are discussing presently. And I think it would be better if we take the two together. The one we are looking at now talks about amendment to the Arbitration and Conciliation Act, while the second one seeks to replace them and reenact. So I think it's better we take the second reading of the two together, consolidate them, and then be able to send them to a particular committee, for consideration. So I'd like to invite the Senate leader to move that we take the second reading of the next bill.
Mr. President, very distinguished colleagues, the sixth order of the day is the second reading of the Arbitration and Conciliation Act Cap A18 LFN 2004, Repeal and Reenactment Bill 2017. Distinguished senators will recall that the bill was read the first time in this chamber on Thursday, 9th March 2017. Mr. President, you may wish to invite Senator Andy Uba to move the motion for the bill to be read a second time.
Senator Andy Uba.
Mr. President, most distinguished colleagues, my name is Senator Andy Uba, representing Anambra South Senatorial Zone. Mr. President, I rise to lead the debate on the bill for an act to repeal the Arbitration and Conciliation Act Cap 18, Laws of the Federation of Nigeria 2004, and reenact the Arbitration and Conciliation Bill 2017 for the modern regulation of arbitration and conciliation processes and recognition and enforcement of the arbitral awards in international commercial arbitration and for other connected purposes. Mr. President, distinguished colleagues, it gives me great pleasure to lead the debate on the Arbitration and Conciliation Bill 2017, which seeks to repeal the Arbitration and Conciliation Act Cap A18, Laws of the Federation of Nigeria 2004. The bill was read for the first time in this hallowed chamber on 9 March 2017. Mr. President, you will recall that this bill forms a part of bills which were highlighted at the inaugural National Assembly Business Environment Roundtable held on 21st March 2016 as capable of improving the ease of doing business in Nigeria and as a result help to rejig the Nigerian economy. No doubt, the process of dispute resolution, especially in a growing economy like ours, can influence the rating of our business environment as either hostile or conducive for investment. Dear colleagues, it is fact that the world has embraced the various mechanisms of alternative dispute resolution as opposed to litigation. Litigation has, over the years, become more cumbersome, lacking confidentiality, time-consuming, and sometimes even more capital-intensive than other methods of dispute resolution, especially in matters involving multinationals. Therefore, the Arbitration and Conciliation Act was conceived in order to regulate the practice of arbitration and conciliation in Nigeria as far back as 1988. However, the Act has now become obsolete, seeing that arbitration practice has evolved all over the world, hence the need for this bill. In order to make Nigeria compliant to the dynamics and indeed international best practices in this regard. Mr. President, this bill seeks, among other things, to further regulate domestic and international arbitration in Nigeria, liberalize international commercial arbitration, provide a unified legal framework for the fair and efficient settlement of commercial disputes by arbitration and conciliation, and also to make convention on the recognition and enforcement of arbitral awards, New York Convention, applicable to any award made in Nigeria or in any contracting state arising out of international commercial arbitration. The provision of this bill encapsulates a finer distinction between the law for domestic and commercial arbitration, introduces the use of technology for the transmission of arbitration agreements, provides for the time within which an application to stay legal proceedings may be made, provides for the right of a party to challenge an arbitrator's competence to conduct an arbitration, enhances the power of an arbitrator to order a party to provide security for costs or power to request evidence on oath, or so many other innovations which all seeks to accelerate arbitral proceedings and to modify the obligations of the parties and powers of the arbitrators in an arbitration, respectively. Mr. President, the import of this bill in the Nigerian business environment cannot be overemphasized. The bill, if passed into law, will attract more foreign direct investments in Nigeria because the law would provide an efficient alternative route to litigation. Also, if this proposal is enacted into law, it will ensure greater participation of Nigerian professionals in the arbitration process across board, as there will be no need for multinational companies to relocate to London or some other sophisticated arbitration jurisdictions in pursuit of justice. The Nigerian economy will be better for it. Lastly, in compliance with Order 77.3 of the Senate Standing Rule as amended 2015, which requires the attachment of a financial compendium to a bill, it is noteworthy to state that this particular bill has no financial implication. Therefore, no compendium is attached to the bill or this debate. Therefore, Mr. President and distinguished colleagues, I crave your support for the speedy passage of this bill in order to bolster the fortunes of the Nigerian economy. Thank you, Mr. President.
All right, thank you, distinguished colleagues. Senator Kofi Ibrahim Umar.
Thank you very much, Mr. President. My distinguished colleagues, let me start by congratulating the mover of this very, very important bill. This is a bill which is very straightforward. Whenever we talk of arbitration and ombudsman, this is a situation whereby the two parties are reconciled. Arbitration, by nature, is meant to be faster because when you are arbitrating, at least the two parties will be there. You reconcile them so that at least they will now agree and arbitration. And normally arbitration is always done in private. So you can see that you are not exposed. When you are going to arbitrators, you are not going to the court. So nobody will see what you are doing. It's simply between the two parties. And then once you agree, then there will be no problem. It is cheaper in terms of because you are not going to the court. And more importantly, it is conducted in private. The two parties, in case if they don't agree, normally they are allowed to go to the court. So arbitration and the ombudsman, they are now the international practice because there are many people who cannot afford to go to the court. So situation where people who don't have money, now they can go to arbitration. So I suggest that we support this bill so that at least we encourage people not to go to the court. Because once we are settling dispute between us, I think it is going to be cheaper, it is going to be convenient, and there will be no much exposure. I have sent support this bill, Mr. President. Thank you, sir.
Senator Lidani. After that, we'll take Aliero and then Dino Malaya, and then we'll put the question.
Thank you, Mr. President. My name is Joshua Lidani. I represent Gombe South. I rise to support that these two bills be referred for second reading and to be consigned to the relevant committees. Irrespective of the bill by Senator Sunmono, it is a very important bill because it is proposing to amend the existing Arbitration and Conciliation Act in several respects. First of all, it makes provision for interim attachment of property or interim preservation of property pending the final determination of the dispute. Because this is a new novel provision, is not there in the existing act. Therefore, it's very necessary that property or the subject matter of litigation be preserved before the final determination thereof. I think it's a very welcome innovation and it's a good one that should be supported. It also makes a novel provision for setting aside previous awards. In the extant law, there is no such provision that that awards could be set aside. Awards under the new proposal could be set aside if there is a fundamental vice that is discovered to have affected the award in the first place, either because the parties were not served initially or because there is a law that prohibits the making of such awards and so many other encumbrances. It's a novel provision which we should all welcome. And also, next provision for orders of forfeiture, interim orders, which preliminary orders. The court can make, or the arbitration panel can make a preliminary order, either for the preservation or for any other purpose, which will aid in the final dispensation of justice. So these are novel provisions in the Act, in the proposed bill, which is very much welcome. However, if the matter goes to the committee, there is a need for the committee to look at the provision for setting aside such interim order, because the interim order is expected to be done without notice to the other party. That is ex parte. If the other party is affected by that order, he should have the right to have it set aside. But there is no such provision in the proposed bill. So I think it's something that when it gets to committee stage, you should have a look at it. The second bill by Senator Andy Uba seeks to replace the entire bill and to reenact it by including provisions that will capture technological advancements in litigation. I think that too is a welcome development, but the committee will have a very difficult job in incorporating the provisions proposed by Senator Sunmonu in the new bill. So they will have to work very hard in order to make sure that in reenacting the bill proposed by Senator Andy Uba, the provisions proposed in the amendment by Senator Sunmonu will be incorporated in the new bill. So I support that this matter goes for second reading so that the committee will have a very thorough look at it and remit it back for consideration.
Sorry. Thank you, Mr. President. Distinguished colleagues, my name is Muhammad Adamu Aliero. I represent Kebbi Central. I rise to support this very important amendment for two reasons. Number one, the present arbitration law is complicated and it takes time to really reach agreement. For that reason, a lot of people get discouraged in going to arbitration. Secondly, foreign investment will always look at your law to see how good it is in case there is any dispute. And presently, a number of investors, foreign investors, are discouraged in investing in Nigeria simply because our arbitration law is so complicated. And thirdly, if this law is amended, there is no need for people to seek for redress in London or in Paris, as presently obtained. Mr. President, distinguished colleagues, I will urge my colleagues to support this very important bill because it will ease business in Nigeria, and we can even extend this arbitration law, if possible, to what is happening in the war against crime. Presently, a lot of money is being held abroad. Only yesterday, I saw a newspaper saying that there is over $550 million that is being held in New York, awaiting to be repatriated to Nigeria. And I think federal government should pursue arbitration instead of going through our legal system. Once they do that, this money can easily be brought within the shortest possible time. I understand that that money has been in dispute for over 20 years. Imagine if we can get that money now, it will boost our economy. State governments will also have a share of it. Local government will also have a share of it. So for this reason, Mr. President, I urge my colleagues to support this very important amendment and pass it into law. Thank you.
Sir Dino Malaya.
Mr. President, my respected colleagues, Dino Melaye, Kogi West. Mr. President, I stand to contribute to the very important bill as proposed by Senator Mansurat Sumonu. For me, the core of our presentation is the noble innovation of proposing the property preservation aspects of the bill. It's a new introduction from the existing Arbitration Act, because many a times, before disputes are settled, the properties in contention get destroyed, vandalized, and in most cases, you find out that people go in and begin to steal these properties or part of the installations of the properties. But now that this introduction is being proposed to the existing act, then the property in question is now properly preserved pending the determination of the dispute. This is a very noble introduction, and I want my colleagues to seriously support it. And this arbitration is very, very, I am particularly supporting it because, one, it is cheap, and there is no winner or loser, because both parties, at the end of the day, they come out victorious, and there is amicable understanding and settlement. And this will also help to decongest our courts if properly promoted. Very flimsy issues that will take 4 or 5 years in civil courts or other lower courts can be settled through arbitration, and this will seriously help in decongesting our courts. Then on Senator Andy Uba's bill, it's a wonderful innovation but not practicable. Right now, the introduction of the entire bill is in the introduction of technology into the administration of justice. But this is not supported by the Evidence Act, because the Evidence Act, as presently constituted, do not support electronic evidence. So for us to implement that, we must first have to amend the Evidence Act before this can be supported. So, but I know when it gets to the committee level, they will look at the nitty-gritty and proper advice will be given. But I do ask that we consolidate the two bills and we allow it to go for second reading. Thank you.
Very well. Senator Binala.
Thank you very much, Mr. President, and my distinguished colleagues. Let me respectfully start by disagreeing with distinguished Senator Dino Melai on the issue of electronic evidence. Our Evidence Act, as of today, is comprehensive enough to admit electronic evidence. And even in those dark days, I remember there is a specific provision that says document produced using the same mechanical process, each copy is deemed to be the original of the other. That is if my memory has not failed me. But I think the most important thing is this. These two bills I have had the privilege of just going through. Before the introduction of this amendment, the complication that distinguished Senator Aleru was trying to bring to fore was the issue that parties are bound by their agreements. And as long as Nigeria continues to get involved in international business, it means certain agreements and elements of certain agreements will have some foreign flavor. And therefore, if, for example, parties agree that the venue for arbitration is going to be London, parties are bound. The problem arises where if an arbitration is reached outside the territories of Nigeria, for you to enforce that arbitral award under the Arbitration Act, you now have to do as if you are going through the entire legal process of calling evidence that yes, the arbitral, the award has been, the proceeding has been done, the award has been reached, and whatever. It becomes under the enforcement of foreign judgments. So the idea is that if these amendments are carefully handled by the committee to which is going to be assigned, these are the issues that we should look at. For example, a provision in the law that deem an arbitral award reached at any territory outside the Federal Republic of Nigeria, provided it is agreed between parties, is deemed to have been reached within the territory of Nigeria for the purpose of enforcement, will be a very helpful step in helping at least the ease of doing business in Nigeria. So I think that the committee to handle this should begin to look along the line of trying to bring less complications into enforcement of arbitral award. I cannot remember, my memory is not too good, but I think it's provided for in section 24 to 26 of the Arbitration and Reconciliation Act, laws of the Federation of Nigeria. So reference to that and reference to the provisions that have been proposed by both distinguished Senator Andy Uba and my big sister, Senator Mansurat, should be taken into account by the committee that is to be assigned with this responsibility. That's the necessary guidance I felt I should give by way of intervention. Thank you, Mr. President.
All right, thank you, distinguished colleagues. I think the place of alternative dispute resolution mechanism cannot be emphasized at this level of our development. And I would like to thank the sponsors of these bills for bringing this up. I believe that our judicial system will be served much better if we develop our alternative dispute resolution mechanism more. And I recall that in the last National Assembly we passed a mediation bill which was not signed into law. So I would like to suggest to the Committee on Judiciary that when this bill is sent to them, they also look at that bill to see if we can have a comprehensive alternative dispute resolution bill that will deal with all matters relating to alternative dispute in the form of the PIB, so that all matters relating to alternative dispute will be in one document, namely the bill or the act on alternative dispute mechanism. I think that will help us a lot because at this stage of our development, we need this alternative dispute mechanism to deal with not just the commercial disputes, but I think it's also important to deal with ethnic tensions, inter-community disputes, can be resolved through alternative dispute resolution, either mediation, conciliation, or arbitration. So this bill is coming at a very important and critical time in our national history that a lot can be achieved using this alternative dispute resolution mechanism. So I'd like to commend you once more for bringing this bill and for the contributions of our colleagues. So on this note, I would like to put the question so that we can take the second reading of both bills and refer them to the appropriate committee. So, dear colleagues, those in support that these bills be read the second time, say aye. Those against, say nay. The ayes have it. Back of Senate.
Mr. President, distinguished senators, the bill for an act to amend the Arbitration and Reconciliation Act, Cap A18, Laws of the Federation of Nigeria 2004, and for other matters 2017, second reading.
Dear colleagues, a bill for an act to amend the Arbitration and Reconciliation Act, Cap A18, Laws of the Federation 2004, and for other matters related thereto 2017, SB 362, second reading taken and referred to the Committee on Judiciary and Human Rights. Clerk of Senate.
Mr. President, distinguished senators, a bill for an act to repeal the Arbitration and Conciliation Act, Cap A18, Laws of the Federation of Nigeria 2004, and reenact the Arbitration and Conciliation Act 2017 for modern regulation of arbitration and conciliation process and recognition and enforcement of arbitral awards in international commercial arbitration and for connected purposes 2017, second reading.
Very distinguished colleagues, a bill for an act to repeal the Arbitration and Conciliation Act, Cap A18, Laws of the Federation of Nigeria 2004, and reenact the Arbitration and Conciliation Act 2017 for the modern regulation of arbitration and conciliation process and recognition and enforcement of arbitral awards in international commercial arbitration and for connected purposes 2017, second reading taken and referred to the Committee on Judiciary, Human Rights and Legal Matters to report back in 4 weeks. So the two bills have been consolidated and referred to the Committee on Judiciary, Human Rights and Legal Matters, and we expect them to report back within 4 weeks. Say, Leader.
Mr. President, very distinguished colleagues, the seventh order of the day is second reading of the Insurance Act
Amendment Bill 2017. Distinguished senators will recall that the bill was read the first time in this chamber on Wednesday, 18th May 2016. Mr. President, you may wish to invite very distinguished Senator Omar Kurfi to move the motion for the bill to be read the second time.
Senator Omar Kurfi.
Thank you very much, Mr. President, sir. My distinguished colleagues, my name remains Umar Ibrahim Kurfi, a senator representing Kaduna Central. This is a very straightforward bill regarding building under construction and building under uncompleted. Mr. President, distinguished colleagues, I am glad for the opportunity given to me to lead a debate on the general principle of a bill or an act to amend the Insurance Act 2004 to provide for a limit of liability in respect of third-party liability in compulsory insurance of public buildings and buildings under construction and related matters. The idea, sir, behind this proposed amendment bill is informed by prevalence of collapsed buildings in many Nigerian cities. The instance is more noticeable in Lagos and Abuja, despite the existence of various societies and leave of quantity surveyors, architects, building engineers, town planners, and their corporate headquarters in Lagos or the nation's capital. There have been spike of a number of building collapses in the country, with over 20 cases recorded over the last 10 years. A lowdown on some of these worst building collapses in the country in recent years, which prompted the need to amend the Insurance Act, are enumerated below. 1. Senegal Church building collapse. The worst building collapse in the country occurred in the Ekotu area of Lagos on September 12, 2014. As that day, a crowded 6-story guest house belonging to the Senegal Church of All the Nations collapsed, trapping about 300 people, of which 116 were killed, inclusive 85 South Africans, with over 100 others injured. The Lagos State government filed a court charges against the registered trustee of the Senegal Church, Hard Rock Construction and Engineering Company, Jendi Trust Limited, and engineer Olade Kunji and the Abuja who built the collapsed building. 2. Lekki building collapse. That was March 2016. On Tuesday, March 8, 2016, around 3 a.m., shortly after a windstorm, a 5-story building under construction in Lekki Gardens, further one in the Lekki Phase 1 area of Lagos collapsed, killing no fewer than 30 persons and injuring several others. 3. The collapse of Titanic building in Abuja on July 18, 2006. The Titanic building was a block of 36 flats, which housed 180 people, collapsed, leading to the death of about 20 people. 4. Mr. President, my distinguished colleagues, the uncompleted building in Abuja, that in August 2010, a 4-story uncompleted building at number 2 Equal Street of Gimbia Street in Gariki collapsed, leading to the death of 21 people out of 30 inside the building. 5. Those building collapse, that is 2013, Abuja, Abu Neighbor Primary Secondary School, Bukuru, just south Lagos, where the place state collapsed, leading to the killing of 10 out of 30 people, mostly below the 10 years old in the building. 6. Another building collapsed in Gebitumeta in July 2013, which was a building that was said to have been marked for demolition a year earlier, killing 7 people. 7. Aya building collapsed in May 2013. This building was under construction in the Abama area of Aya Abia State. It collapsed and killed 7 people. 7. 8. The collapse of abandoned church building in Ongondosa, Kaduna, leaving 5 people dead. 9. Bank of Industry 21-story building collapsed in March 2016 in Broad Street, Lagos, leaving 2 people dead and 23 others injured. 10. Collapse of house number 12, Hadeja Road, Kaduna, on July 11, 2013, leading to killing 3 people aged between 9 and 14. Mr. President, sir, my distinguished colleagues, this bill is proposed to ensure compliance with the compulsory insurance of public buildings and buildings under construction by relevant stakeholders in Nigeria. Most importantly, it is found necessary in view of the paucity in the existing law characterized with inadequate penalty provision against any person or group of persons or entity liable to building collapse and a non-existing provision of minimum sum to be insured for building under construction. Objective of the bills. The bill seek 1, to provide security or as remedy for victims of collapsed building. 2, to fill the gap in the failure to provide limit of liability in respect to third-party liability in compulsory insurance of building and building under construction. 3, provide adequate penalty provision in the context of current socio-economic realities for contravention of the law. 4, restore the glory of insurance industry, which characterizes with gap addressing the multiple risks in the contribution of industry. Mr. President, my distinguished colleagues, the gap and inadequate in the existing law. 1, technical construction phrases which makes understanding very difficult. 2, inadequate penalty provision for contravention of the law. 3, non-existing provision of minimum sum insured of collapsed buildings under construction. So now I go to specific amendments. Existing and amendment. 1, existing law. 1, section 64, subsection 1, the phase any building of more than 2 stories to be simplified. The amendment now is the phase should be specified to read building of more than 1 story. 2, existing law, section 64, section 3, inadequate penalty in contravention of the law, which attracts a mere fine of 250,000 or 3 months imprisonment or both. Amendment suggested the penalty should be made steeper, i.e. a fine of 500,000 or 3 years imprisonment or both. Third amendment, there is no provision of minimum sum insured. We are suggesting the minimum sum insured should be fixed to 2 million. Significance of this amendment: 1, it makes our law dynamic and realistic. 2, it protects the right and interest of victims of collapsed buildings. 3, it makes the law to be in conformity with international best practice. 4, it restores public trust and confidence in the insurance industry, which is considered by many Nigerians as non-performer in claim settlements. 5, it will instill sense of discipline in the construction industry. 6, it gives effect to constitutional provisions that guarantee life, right of life. In conclusion, sir, my distinguished colleagues, I wish to raise my case to allow contribution which I strongly believe will both enhance the quality of the proposal and facilitate speedy passage. I remain grateful to my Mr. President and my distinguished sir. I so submit.
Senator Gabriel.
Thank you very much, Your Excellency, distinguished colleagues. This bill is a very important bill, and I would like to use this opportunity to thank the mover of the bill, or the sponsor, because of its importance. The real issue here is that in addition to actually insuring or having the minimum limit of insuring a building, there is also a need to look at exactly how insurers are paying back the money. Because the important thing here is that many insurers and stockbrokers or the brokers are actually idling with people's money without having to pay back the compensation. I think it is important to look at both the two, as brought by the chartered insurance broker, as he is. We also have to look at the issue, how this money should be paid. But if you look at the way the interests of both the victims, that is in terms of, even the building owners itself and the victims, then it also helps the insurance brokers themselves, and therefore the bill is very important. I support it, and I hope it will be given a speedy passage. Thank you very much, Your Excellency.
Senator Francis Alamekena.
Thank you, Mr. President. My name is Senator Francis Alamekena, representing the good people of Edo North. Mr. President, I rise to support this bill, which is a straightforward bill moved by my friend, distinguished Senator Kofi. This insurance bill is a nice thing to do in all over the world. It's not only public buildings that they need insurance. Even the private building also need insurance. The attitude of most Nigerians, why they don't pay insurance bill,
is because of the attitude of the insurers themselves. To pay claims is a problem. And it's because they don't pay claims that Nigeria are not used to insurance. Insurance problems are supposed to be good thing for everybody. Even insurance
claims. As you've heard, there are some bills being considered within the plenary. One of the bills that actually has been put forward and has been deliberated upon is the bill for an act for the provision of the suppression of piracy and to provide for the punishment of the offense of piracy and for matters connected there within. We have here the mover of that bill, or sponsor of that bill, Senator Nelson Effiong, representative from Akwa Ibom South. Sir, tell us more about the bill that you have released.
Actually, it's anti-piracy bill. Right. You know, the act of piracy has been on the increase in the Nigerian territorial waters and the Gulf of Guinea as a whole. And it is becoming an embarrassment to us. As a matter of fact, cases of piracy are going down in other countries. Even Somalia, that was notorious for piracy, the cases are going down, but it's increasing in Nigeria. The International Maritime Bureau has been hampering on how Nigeria can effectively protect its territorial water. You know, Nigeria is an import-dependent country. Yeah. In fact, if you remove the sea, there will be no country called Nigeria, because almost 80% of what we eat and what we use in this country is imported. And Nigerian importers have been having a problem bringing goods into this country because of the high cost of freight. The ship owners have increased their freight charges, and the insurance premium on the ships have increased because of the problem of piracy in our waters. And that cost is transferred onto the final product for the common person to pay. You know, so it is a worrisome trend that we don't bring a proactive legislation, as I've done today, to stop this and met adequate punishment to offenders. In fact, in the bill, I have proposed life imprisonment for piracy offenders and death penalty if during the act of committing the piracy somebody dies. The person should also be killed.
What is the penalty as we...
That's what I'm saying. I'm proposing life imprisonment for the mere committing the act of piracy. Yes. But when in the process the offender killed somebody, it should be a death penalty.
Yeah. No, what I'm saying, what is the law? What is it?
The Criminal Code Act, Section 401 and 402, merely treats piracy as ordinary armed robbery. You know, and it does not specifically treat it as a crime committed on the high seas, because most of the victims, you know, of this crime can be international people from other countries. So we cannot afford to treat it as ordinary armed robbery within the Nigerian country. And what I want to say also is that we must separate this piracy offense, just like we have separated corruption. You know, during the process of treating corruption, a crime called corruption, we had to establish the FCC and treat it as a separate crime. Yeah. Even Boko Haram case, terrorism, is treated separately. So we should not lump it as armed robbery. Okay. So that is why I'm proposing that we should pass this bill into law and make it very effective in curbing the menaces of piracy in our territorial waters and the Gulf of Guinea.
Okay, and then quickly, what must we then do in addition to that to make our seas more effective? Some people said our seas are docile, dormant.
Yes, absolutely. In fact, first, if we can get our acts together and pass this bill into law to protect our seas, then we should energize the maritime sector in this country. Some years ago, the National Assembly passed the cabotage law. That was to get Nigerians to take part in the shipping industry actively. But unfortunately, because of the highly capital-intensive nature of the profession of the business, Nigerians cannot afford. So it is necessary for government to come in. I know that we had an ugly experience when we floated Nigerian National Shipping Line, but that should not discourage us from trying something again, because most of our trained seafarers and sea maritime sector workers are idle. Most of them even finish from the Maritime Academy and cannot even gain sea experience because of the high cost of going to the foreign, trying to go into the foreign ships. But if we have an indigenous shipping line, we will be able to help them to gain sea-going experience. And I think the government should think in this direction.
Thank you very much indeed.
Thank you.
For sharing your experience. Yes. Well, you've just heard it. Our sea and ports are, as some people say, a bit dormant, and they need to be reactivated. And then, of course, also the issue of security in order to make it more effective and then more beneficial to all concerned. This is how far we can go on this edition of the program from the National Assembly Senate Live, coming to you from the Nigerian Television Authority. On behalf of all the crews and members of this production, this is Wazir Zayyad saying have a very pleasant day ahead, and bye-bye.